like Fervent's brilliant. Like, this shit is fucking hilarious.
Fervent giving a nice shout out here. Kelly Reed giving a nice shout out to Fervent here. You have great videos, she says. Absolutely. Fervent's got great videos. Follow him on Twitter.
Think you're better than me? Well, why don't we see?
We lost.
That's a friggin' banger, right? Fervent, can I was like, woohoo, that is so good.
Now, you are amazing. Thank you. I love your parody videos. Keep them going. If you do that for every trial, honestly, I think we need comic relief, especially in this space, because it's depressing to watch trials sometimes. It's very taxing.
If you go to Fervent on Twitter,
Fervent. Yeah, go to Fervent.
Get a different screen open, put in your Twitter, go to Fervent, and then just share it.
You don't have my Twitter hooked up to the computer.
Fervent.
Fervent?
Yes. Fervent HOSP, if that's the app thing.
Oh, Fervent what?
HOSP. For probably hospital, I don't know.
Sure.
Or
Can you at some point explain what fervent hosp means? Is it like hospice care? Is it a hospital? Are you a hospitality group? Are you hospitable? Long to dying cold? What is hosp? What is fervent? What is life?
What's up, unnamed Fervent fans? Happy Valentine's Day to both those that celebrate it and those who loathe it. Today we're going to be creating the ultimate definitive opening statement for the Karen Reed trial. What we're going to do is we're going to look at both the opening from Trial 1 by Attorney David Yannetti and the opening from Trial 2 by Attorney Alan Jackson, splicing them together the best we can, taking the best of each statement and coming up with a pretty badass opening statement. Quickly before we begin, you're going to see in the top left of the screen a little bar with my Venmo information if you want to support the channel. Again, no pressure whatsoever. And two things I want to address. One is people are clamoring for merch more than I ever thought they would. So this is a channel for the people. I'm here to give you what you want. I'm in the lab cooking up some designs that I think a lot of you will really enjoy, so stay tuned for more news on that front. Also, people ask, when are my songs going to be on Spotify? That is also coming soon. I'm hoping by the end of this month, I can get that done for you guys. All right, let's get in to the opening statements.
Thank you, Your Honor. May it please the court. Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death. And that means that somebody else did. You will learn that it was no accident that John O'Keefe was found dead on the front lawn of 34 Fairview Road in Canton on January 29th of 2022.
May I, Your Honor? The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle. Period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, There was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for an event that literally never happened?
You will learn that at that address lived a well-known and well-connected law enforcement family in Canton, the Alberts. Because the Alberts were involved, and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit. From a very early juncture in this case, you will question the Commonwealth's theory of the case. You will question the quality of the Commonwealth's evidence. You will question the veracity of the Commonwealth's witnesses. And you will question their shoddy and biased investigation, a faulty investigation that led to Karen Reed sitting here today. You will learn, in short, that the police did no real investigation of this case, and you will question why. You will question why the investigators had such tunnel vision. You will question why they focused solely on Karen Reed, someone with no ties to the Canton Police Department, as opposed to the well-known and well-connected Albert family of Canton, a family that was never treated as suspects by the investigators in this case.
And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case, and he was talking about a fellow officer, a fellow cop, who owned the property where John O'Keefe's body was found. Text message with a buddy. Question: is the homeowner going to catch any shit? Answer: nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means.
Michael Proctor, you will learn, is one of the many people in Canton with deep ties to the Albert family. Michael Proctor's own mother refers to the Alberts as the Proctor's second family. His own sister's wedding, Michael Proctor was in the wedding party with Colin Albert. And he sat at the head table of that wedding with members of the Albert family. That's the man who was chosen to lead the investigation into the suspicious death on the property of Brian Albert. That's the man who gave updates to Canton Police Officer Kevin Albert, while the state police were supposed to be investigating what had occurred at his brother Brian Albert's house. You'll learn that right from the jump, Michael Proctor predetermined the outcome of this case. Never stepped foot inside the Albert home on January 29th, 2022. Never checked out whether there were any signs of struggle inside that home. He never called for crime scene technicians and other specialists to look for blood or other trace evidence within the home. He never asked Brian Albert for permission to go in the home and take a look around. Michael Proctor never applied for a search warrant to go in that home. Instead, he focused immediately and exclusively on Karen Reed, the outsider. You will learn that no one in the Proctor family has ever called the Reed family their second family. No one in the Proctor family had been in a wedding party with anyone from the Reed family. Karen Reed was a convenient outsider. She was most definitely not from Canton. So how did Michael Proctor feel about her? How did he treat somebody he was investigating at a point in time when he should have been keeping an open mind and focusing on obtaining all possible evidence so that he didn't miss anything? Well, you will learn that on the very day that John O'Keefe was found dead on Brian Albert's lawn, Michael Proctor was texting with his high school buddies about this supposedly secret investigation using his personal cell phone. He was revealing information about this investigation to his friends, assuming that nobody would ever find out what he was doing and what he was saying. And he was revealing his true thoughts about Karen Reed to his friends, not what he put in his sanitized police reports, his true feelings to his friends whom he trusted, and in text messages that he never thought would come into the hands of the defense in this case. Lead investigator Trooper Michael Proctor, right from the start, called Karen Reed names you would reserve only for your worst enemies. He told his friends that he hoped that she would kill herself, that he had seized her cell phone. And you will learn that he knew he shouldn't have been accessing any content on her cell phone because he knew there would likely be attorney-client communications on it between Karen and me at that time. He knew that he was supposed to wait for a search warrant or other permission from a judge in order to go through that phone. But you'll learn that he went through the phone anyway, without permission. And you'll know that he did because he told his high school buddies that he was searching her phone for nude photos of Karen Reed. And he was disappointed he hadn't found any yet. That is the professional and unbiased investigator who was chosen to lead the investigation into the death of John O'Keefe.
More shockingly, you'll learn that lead investigator for the Massachusetts police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses, he never properly collected evidence, he never secured the evidence, he never searched for signs of a struggle inside or outside the home, he never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of his, of Michael Proctor's, actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part, that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went.
And folks, you will learn that the timing is important, very important. Because when John O'Keefe was first found on Brian Albert's front lawn, the police thoroughly searched that yard for potential evidence. And it wasn't just one officer, or two, or three. There were at least 4 officers that searched that front lawn. And that morning was the beginning of a snowstorm, but there wasn't yet much snow on the ground when they were searching that lawn. It was light out by the time they did the search, and it was getting lighter. And during that thorough search of Brian Albert's front lawn, the number of pieces of tail light that were found by a minimum of 4 officers looking for evidence was 0. It was only later in the day, when the snow was really starting to accumulate, that the police miraculously started to find pieces of taillight on the property.
Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants, he transported the evidence, he secured it, he submitted it, he did it all. That's Michael Proctor. And he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found him guilty, found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? Well, the evidence is going to show that Michael Proctor earned it. Every bit of it.
Boston police officer John O'Keefe was found mortally injured on Brian Albert's front lawn. His body was in full view and almost right below Brian Albert's bedroom window on his front lawn. He was found wearing only one sneaker. You'll learn that Brian Albert was a Boston police officer as well, and that he was a trained first responder. Brian Albert was notified that another police officer was injured and unresponsive on his front lawn, and Brian Albert did nothing. His sister-in-law, Jennifer McCabe, and other civilians were on his property that morning after John O'Keefe's body was found. Police, EMTs, firefighters, police cruisers, an ambulance, fire truck, lights flashing, and first responder Brian Albert never came out of his house.
And what else you'll learn Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident.
You'll learn that some other curious things were going on in the early morning hours of January 29. Curious things that the police in this case utterly failed to investigate. For example, after people left the after-hours party at Brian Albert's house on January 29, Brian Albert claimed that he had no contact with anyone but his wife until he was woken up in the morning. But you will learn that he was ultimately confronted by the fact that his phone records revealed that he had actually placed a phone call to ATF agent Brian Higgins, his friend, the same friend who had been at his house earlier that night. And that was at 2:22 in the morning. You'll learn that Brian Higgins called him back 17 seconds later, and they connected 22 seconds on their cell phones. You'll be asked to consider just how long 22 seconds is, and what could be said and discussed during that long of a phone call. You will consider that phone call in the context of the other curious things that were going on during the early morning hours of January 29th. Karen was panicked at that time. Where is John? Why didn't he come home? What happened to him? And you will learn that she was racking her brain for what possibly could have happened. And like many of us, was worried about the worst. Did I hit him? Could I have hit him? That was what she was saying, both to herself and to other people later that morning when she went back to 34 Fairview. She couldn't think of anything else that made sense. He certainly didn't consider in a million years that someone from within the Albert home could have beaten up John and left him to die on the front lawn.
She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other. A woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that the evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, I hit him. Not one. Not one civilian reported having heard Karen Reed say, I hit him. The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert. Brian Albert's brother. But there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been, had he actually been there, right after 12:30 a.m., which is what the Commonwealth's claim is.
Brian Albert's sister-in-law, Jennifer McCabe, was there. Her husband, Matthew McCabe, was there. ATF federal agent Brian Higgins was there, who was also Brian Albert's friend. Sarah Levinson, a friend of Brian Albert Jr., was there. Julie Nagel, another friend of Brian Albert Jr., was there. And Caitlin Albert, Brian Albert's daughter, was also there. All of them leaving the residence. Each of those people left 34 Fairview in Canton, where Brian Albert lived. Each of them walked out facing the front lawn, where the Commonwealth will tell you that a 6'2", nearly 220-pound big man in dark clothing was sprawled on the front lawn when there was only a dusting of white snow on the ground. He was supposedly sprawled on that lawn, just feet from where these people were walking when they left the residence. And you will learn that not one of these people saw John O'Keefe laying. Not one.
Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning.
And you know who else saw no one laying outside in the early morning hours of January 29th? The snowplow driver in charge of plowing the street for the city of Canton. And this is another big problem for the Commonwealth. You will learn that Michael Proctor, here's that name again, wrote a report where he claimed that the DPW supervisor had told him that Fairview Road had not been plowed that night. Proctor's total investigation on this issue consisted of one phone call and no follow-up. He just submitted his report that simply said the road hadn't been plowed that night, and perhaps thinking that no one else would follow up either. But you'll learn that when it came to finding out the truth, it's not that Proctor couldn't find the truth, it's that he wouldn't. But fortunately, you'll learn that we would, and we did. You'll learn that within weeks after January 29th, we sent our investigator, a former Medford police officer named Paul Makowski, to the Canton DPW to try to get to the bottom of this. Paul Makowski talked to the same supervisor at the DPW, a man named Michael Trotta, whom Proctor claimed had told him that the street hadn't been plowed that night. You'll learn that Paul Makowski found out that Michael Proctor was not telling the truth. You'll learn that Michael Trotta from the DPW told Paul Makowski, our investigator, that the street was indeed plowed that night, and that the name of the plow driver was Brian Loughran. So Paul Makowski tracked down Brian Loughran. He asked Mr. Loughran if the state police or any investigators had ever spoken to him. And the answer came back, no. You will then learn what Brian Loughran had to say about what he saw and didn't see that night, and you will be shocked. Brian Loughran told Paul Makowski that he was driving a big snowplow in Canton that night. You'll learn that the nickname for it at the DPW was Frankenstein, because it had a lot of spare parts and it had been around forever. Brian Loughran told Paul Makowski that when he plows the streets of Canton in Frankenstein, he's very careful. He makes sure to check not only the roads in front of him, but also the yards to the side of his plow. He makes sure not to hit a fire hydrant or a tree or an animal, or heaven forbid, a person lying in the snow. He's always on the lookout. You'll learn that Brian Loughran passed by 34 Fairview in his plow, traveling right by Brian Albert's front lawn at 2:30 in the morning. You'll learn that Brian Loughran confirms that at about 2:30, when he went by that house, John O'Keefe was not on that front lawn. So you'll learn that about 2 hours after the Commonwealth claims that Karen Reed somehow incapacitated John O'Keefe, an eyewitness confirms that not only could it not have happened, but it didn't happen. But you'll learn that Brian Loughran also provides some other troubling testimony for the Commonwealth. You learn that after making that pass at 2:30 in the morning and seeing no body, he showed up again at the entrance to Fairview Road, intending to make another pass down it with his plow. This time, however, at about 3:30 in the morning, he looked down the street and he saw that parked right next to Brian Albert's front lawn, right in the very area where John O'Keefe's body was later found at 6 a.m., Brian Loughran saw a Ford Edge parked on the side of the road.
You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road?
You will learn that the police have done zero investigation to discover whose Ford Edge that was. You'll learn that members of the Albert family drove Ford Edges. You'll learn that the police to this day claim not to know who was parked right next to the area where John O'Keefe's body was later found. You will learn that while investigators on this case, including Michael Proctor, completely ignored the snowplow driver who went right by the Albert residence, the defense not only tracked him down and interviewed him, but the plow driver actually took our investigator on a ride back past the residence.
Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence, from a forensic software program called Physical Analyzer made by Cellebrite, it's considered the gold standard for forensic tools.
Thinking she was alone with her thoughts, and not worrying that anyone would know what she was doing, Jennifer McCabe typed in the following Google search: how long to die in the cold? Now, she misspelled the first word, so the actual search was "how to die in the cold," but you'll get the point. You will ask yourself, why would somebody Google how long does it take for someone to die in the cold? Unless that person knew someone who either was in that situation or would be in that situation. You were questioned during this trial. Who was it who actually did die in the cold at some point that night? Sometime after Jen McCabe was asking Google for an answer to her question. And you'll learn that the answer to that question was John O'Keefe.
A Google search that Michael Proctor and his investigators never revealed to us. But we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. How long does it take to die in the cold? Time-stamped, 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Brians, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that, too, is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation. A butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m. and why did they both try to cover up that phone call? You'll also learn after this incident and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them.
We'll learn about the following in chronological order.
1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making.
2:12 a.m., Jennifer McCabe arrives at her home. 2:22 a.m., Brian Albert calls Brian Higgins. 2:22 a.m., 17 seconds later, Higgins calls him back. And Brian Albert and Brian Higgins are on the phone together for 22 seconds. 2:23 a.m., Jennifer McCabe climbs the stairs to her bedroom. 2:27 a.m., Jennifer McCabe searches on Google how long to die in the cold.
Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own.
The Commonwealth will not be able to successfully dispute any of those facts, yet I expect that they will persist in asking you to convict Karen Reed anyway.
We'll introduce you to a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where, ultimately at 6 a.m., Karen found him the next morning.
We learned that when John O'Keefe was found, he did not look like he had been hit by a car. You'll learn that he looked to have been attacked and beaten up. You'll learn that John O'Keefe was a large 6'2" man who, if positioned behind a Lexus SUV, would have had his torso completely exposed to the rear of that vehicle, including to the taillight.
You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. Lopesada will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision.
The evidence will show that what was not pristine was his right arm. You will take one look at that arm, and you will conclude that a car did not cause those injuries.
She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. Lopesada. The evidence will show that these injuries are from an animal, like a large dog,
Those marks are consistent with scratch and claw marks and bite marks from an animal, including a German Shepherd. You'll learn that on January 29th of 2022, Brian Albert's family dog, Chloe, was a German Shepherd. You'll learn that Brian Albert has admitted that this dog is not good around strangers. You'll learn that on January 29th of 2022, John O'Keefe would have been a stranger to that dog.
You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her. But she was gone. The evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt.
So folks, the trial is now about to start, and the witnesses are about to start testifying. On behalf of Karen Reed, I ask that you do 2 things during this trial. First, I ask that you pay attention to all of the evidence. The way trials work, the prosecution gets to present its case first. They conduct their direct examinations first. So we respectfully ask that you wait for us. We will get to cross-examine their witnesses, and you will find that cross-examination is the key that unlocks the truth. Wait for us. You'll be glad that you did.
Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden of proof.
I ask that you keep your eye on the ball here. You have one job and one job only to do during this trial, and that job, quite frankly, is not to solve this case. Your only job during this trial is to determine whether the Commonwealth, the prosecution, has proven to you each and every element of the crimes they have charged, beyond a reasonable doubt, to a moral certainty. The prosecution will fail to prove this case to a moral certainty. They will fail to prove this case beyond a reasonable doubt. You will reasonably doubt their case because their theory of the case does not make sense.
You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you. not when the conduct of those in the House and the utter lack of investigation speaks volumes about those who actually have something to hide.
You will reasonably doubt their case because Karen Reed was framed, and the evidence shows that, despite the fact that the police never ever investigated that angle of this case at all. Because the prosecution will not prove their case beyond a reasonable doubt through a moral certainty, we will stand before you again at the end of this trial.
By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all three of them, that are consistent with the evidence, the science, the truth, and justice.
Not guilty.
Not guilty. Not guilty. Not guilty. Thank you.
Mr. Foreman, on docket number 2282CR117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
So say you, Mr. Foreman? So say you? No. Do you agree?
Yes.
Do all of you agree?
Yes.
Thank you. 002, what say you? Is the defendant at the bar not guilty or guilty?
Not guilty.
Of.
Is not guilty or guilty of that charge or any lesser included charge?
Lesser included.
Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Correct?
Yes.
So say you, Mr. Foreman?
Guilty.
So say you all?
Yes. Guilty.
003, what say you? Is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty?
Not guilty.
So say you, Mr. Foreman? So say you all? Jurors, hearken your verdict as the court records that you upon your oath say the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back. Your service is complete. I'd like to come back and talk to you for a little bit afterwards. So thank you very much.
All rise. Jurors, follow me.
I put you on a pretty list. I'm gonna make you pay for this. Your AJ's dangerous. Ooh, oh baby, I was born for this.
Yeah, I brought the West Coast to Dedham. Nobody is safe from my verbal venom. Put a witness on the stand and watch me shred 'em. Have 'em praying for peace, like the name John Lennon. A lawyer to match me? Well, I ain't met 'em. Don't believe me? Just ask Hank Brennan. Free can't read, and that was just the beginning. I'm never tired of winning. Got these middle-aged women waiting up to go swimming. Let's swim. I don't get nervous. I make people nervous. I don't get nervous. I make people nervous. I put you on a ready list. I'm gonna make you pay for this. LAJ's dangerous. I put you on a ready list. Sorry, Paul Pierce, Ray Allen, and KG. The real big threes, Yannetti, Bob, and me. Gonna come with the seat? Don't try me. You should know by now I always come with receipts. I'm out here penning letters like my name better roll. You got problems, Cox, and I think they're federal. Attorney Corey Hopkins, sure let him know. This ain't an episode, this a whole damn show. I don't get nervous. I make people nervous. I don't get nervous. motherfuckers. Ha ha! I'll put you on the Brady list. I'm gonna make you pay for this. Oh, yeah, AJ's dangerous. Ooh, I'll put you on the Brady list.